Legacy Builders, welcome to the second chapter of the IP for Business Blueprint course. I'm Jenn McNeely with JWM Designs and Marketing, and in this lesson, I'm going to talk about copyright, what it is, what it protects, what things can be copyright protected, and the difference between a registered and unregistered copyright. This is the first video in the copyright chapter of my intellectual property course, and it is packed with a lot of information. Why now? If your business creates or uses any original works of authorship, such as songs, artwork, photography, videos, writing, or software, you need to understand your rights when it comes to your creative works and how to properly use other people's creative materials in your business to avoid potential infringement. Knowledge of these things not only protects your business from people who may want to profit off of your hard work and good reputation, but it protects you from trampling over other people's rights. This lesson will provide you with the foundation you need to understand your ownership rights in copyright. With that being said, let's dive in. Copyright protects original works of authorship, including literary, dramatic, musical, and artistic works such as poetry, novels, movies, songs, computer software, choreography, sculptures, photography, website, graphics, architecture. To be clear, copyright does not protect against ideas and facts. It does protect the way in which those ideas and facts are expressed. When I say expressed, I mean that in order for copyright protections to attach to your creative work, it has to be affixed to a tangible medium, like paper, a canvas, audio recording, or videotape. The protection is automatic the moment you express your original creative idea or facts in a tangible medium. Similar to trademarks, you do not need to register your copyright in order for these protections to attach. By virtue of simply being created and affixed to a tangible medium, you are now the proud owner of a copyright. Congratulations. Here's a pro tip. If the creative work is made by an employee in the course of employment, then the work is considered a work for hire and the employer, not the employee, owns the copyright. We'll talk more about that in another lesson. What does it mean to own a copyright? There are several distinct ownership rights that go along with owning a copyright. As the owner, you have the exclusive right to reproduce the work, to display and perform the work, distribute the work, and prepare adaptations or derivative works. As the owner of the copyright, you can transfer one or more of these rights to a publisher or a distributor to get your creative work out to the public. For example, if you write a novel, you can transfer certain rights to a publishing company to reproduce and distribute the novel for sale in the market. The transfer of these rights can be for a set amount of time, limited to a geographical area, or just for specific platforms. This sort of limited transfer is what's known as giving a license. We will talk more about licensing in a separate lesson. Limits of protection. Generally, most copyrights for creative works made after January 1978 last for the life of the author plus 70 years. There are some exceptions. Under certain conditions, a copyright can last between 95 to 120 years if it was created as part of a work for hire agreement or was published and registered anonymously or under a pseudonym. Once a copyright expires, it goes into the public domain and it is available for anyone to use. For a copyright work to fall into a public domain, it simply means that anyone can use it without the permission of the author or the author's heirs. For example, as of the publication of this video lesson, Disney's copyright for Steamboat Willie, starring none other than Mickey Mouse, is set to expire on January 1st, 2024. If the United States Congress does not change the law again, Mickey Mouse, as we first met him in 1923, will be in the public domain. And between the years 2025 and 2031, Batman, Snow White, and Bugs Bunny will also fall into the public domain. But don't get too excited. While some of the copyrights for these creative works that we've loved with these beloved characters, they may expire soon, their owners still retain certain control over the later incarnations of them, as well as any associated trademarks in them, which do not ever expire. What is not protectable? Now that you know what can be protected by copyright, let's talk a little bit about what is not protectable. Copyright protection for an original work of authorship does not include any idea, procedure, process, system, method of operation, concept, principle, or discovery. Generally, short phrases like titles, names, or slogans are not protectable. For example, in the song Shake It Off by Taylor Swift, she uses the phrase, "haters gonna hate." Although the full song recording and lyrics are copyright protected, the phrase "haters gonna hate" is not protectable. Another example of things that are copyrightable versus things that are not would be recipes or lists of ingredients. A book of your grandma's favorite recipes for dessert with notes about how she created those recipes is copyrightable, but a list of the ingredients for her recipes are not. Other things that are not protected under copyright are things like a math formula or algorithm, but a textbook that includes those items is protected. The content of your business website can be copyrighted, but the domain name is not. Registered versus unregistered copyrights. This brings me to one of the biggest areas of uncertainty when it comes to intellectual property rights, and that is whether a copyright has to be registered in order to protect your creative work. The answer is no. Simply by expressing your original work in a tangible medium, copyright protections automatically attached. What registering your copyright does is put the public on notice that you are the author of the work and have the exclusive right to reproduce, display, perform, distribute, and adapt the creative work. Do you need to be registered to use the copyright symbol? The answer again is no. In fact, for works published after March 1989, you don't even have to use the symbol in order to protect your work. But, and that's a big but, it's not a bad idea to go ahead and attach the symbol, the date of publication, and the author's name to all of your creative work. Doing so helps to remind those who come across your work that it is copyright protected and that they will need permission to use the work. Providing notice with your copyrighted work may be useful if you need to file a copyright infringement lawsuit because the infringer cannot claim that they didn't know the work was protected by copyright if the correct notice was provided. So what's the benefit of registering my creative work if I already have rights without it? Well, there are a few key reasons why you would want to register your copyright materials. First, if you want to sue anyone for copyright infringement, you need to have registered your work prior to suing. Second, if you register your work before someone has infringed on your copyright work or within 3 months of first publishing your creative work, if you successfully win your copyright infringement lawsuit, you may be entitled to money damages plus your attorney's fees. The registration process is not very difficult, and we will talk about how to register your copyright in a future lesson. What if I have completed the registration process and someone is infringing on my work? What do I do? Well, as I mentioned, your work has to be registered in order to file an infringement lawsuit. However, once the registration is complete, you can retroactively recover for the infringement. Why is understanding the basics of copyright so important for business owners? Well, depending on your business, you likely come in contact with copyrighted material on a daily basis, whether it's the materials you've created or materials that others have created. Think about the time that you've used an image or a meme you did not create in a social media post. That image is copyrighted and could lead to an infringement lawsuit depending on the litigiousness of the owner of the copyright. How many times have you heard about a celebrity being sued by a photographer for posting a photograph of the celebrity that was taken by that photographer without their permission? Even though the image was of the celebrity, the copyright owner is the photographer who took the photo, not the person who was in the photo. Crazy, huh? Think about the images, words, or embeds on your website and in your business materials. Do you own the right to use everything on your website? In the e-notebook, I have created a website term of use template that you can copy and make your own and add that to your website so that when visitors come, they have a better idea of the materials or the nature of the materials on your website. Let's recap. In this lesson, I talked about copyrights, what makes something a copyrighted work, the limits of protection, what sorts of things can be copyrighted, and the difference between a registered and unregistered copyright. In the next lesson, we're going to dive a little bit deeper and discuss transferring ownership in your copyright by licensing it or assigning your rights to someone else. Your action steps for this lesson is to do an inventory of your website, social media posts, and marketing materials to make sure that you have the right to use all of the images, graphics, or content on those social media and website platforms. Additionally, I want you to start adding the copyright symbol to your websites and other published copyrightable materials so that you can start putting the public on notice that you claim ownership rights in your creative works. I hope that you found this first lesson in the copyright chapter to be helpful. We are going to dive just a little bit deeper in this topic in the coming lessons. Please post your questions or comments on the video in the comment area below. You can also post questions and comments in the private Facebook group for this course. Remember, you can also find me on Facebook, Instagram, and LinkedIn, and my handles for all those sites are listed in the course resources area, as well as your ebook. This is it for this lesson, so until the next lesson, keep building, y'all.